May I please, your Lordship. Lordship, I beg to mention for listing, one I has been filed for bail, my lord. In the life conviction, my lord. Matter was last posting, my lord, on, my lord, 12/6/2024, my lord.
Next week?
Next week. Obviously.
Yes.
So in item number 14,
Hmm.
my lord, I've been appointed as amicus, my lord. I pray for some time, my lord. I have not prepared the brief, my lord, today.
Okay.
Next
On the,
week, any date, my lord. Tuesday.
on the prayer of Mr. H. Gupta, learned amicus curiae for the appellant, release the appeal after a week on a date to be fixed by the office.
My lord.
As the prayer is not objected by Mr. K.K. Das, learned additional public prosecutor appearing for the respondent state.
Obliged.
Whether this for admission, I don't know what.
পড়ে যাব amicus দিব লাগিব নেকি this criminal appeal from jail is preferred against a judgment and order dated 6/11/2023 passed by the Court of Learned Special Judge within bracket POXO, Tinshukia in POXO case number 44. Special Judge POXO Tinshukia. POXO case number 7 of 2021.
I can read.
Legal Aid Council.
Yes, sir.
Hard MS SS Hajorika. Learned Legal Aid Council. And Mr. K.K. Das, learned additional public prosecutor for the respondent. State number 1, State of Assam. Post of this criminal appeal is preferred against a judgment and order dated 23/02/2023 passed by the Court of Learned Special Judge Jorhat in special case number 29 of 2019, arising out of Morioni Police Station case number 130/2019. Full stop. By the judgment and order dated 23/02/2023, the accused appellant has been convicted for the offenses under section 376 within bracket 3, your name please?
MS Asdev.
Asdev. Hard MS Asdev. Learned counsel for the accused appellant and Mr. K.K. Das, learned additional public prosecutor for the respondent state. Post of this criminal appeal under section 374(2) Code of Criminal Procedure 1973 is preferred against a judgment and order. The judgment and order dated 30/01/2024 passed by the Court of Learned Additional Sessions Judge Bilasipara, District Dhubri in sessions case number 66 of 2016. Post of. In sessions case number 66 of 2016, 9 accused persons, including the accused appellant within bracket A5, stood trial. Post of. After conclusion of the trial, the learned trial court by the judgment and order dated 30/11/2024 has convicted all the 9 accused persons, including the accused appellant, for the offenses under sections 147, 148, 323, 324, 326, 302, stroke 149, Indian Penal Code. Full stop. For the offense under section 302 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for life for the offense under 302 stroke 149 IPC, and to pay a fine of rupees 10,000, with default stipulation, full stop. For the other offenses, the accused appellant has been sentenced to undergo different terms of imprisonment, full stop. It has been further ordered that all the sentences would run concurrently, full stop. The criminal appeal is admitted for hearing. The case records of Sessions case number 66 of 2016 we call for. Issue notice returnable in 4 weeks. As Mr. Das, traditional public prosecutor, has appeared and accepted notice on behalf of the respondent state of Assam, issuance of formal notice to the respondent. Said respondent stands dispensed with. Release the case after 4 weeks.
Item number 5 for orders.
May it please your lord. Lordship may kindly peruse the order dated 22/1/2024 passed by this honorable court. 22nd January 2024. One inquiry report was called regarding juvenility.
Let
of
me
the-
read.
Yes, and that is.
Let me read. Okay.
Report in terms of that order is received. Lordship. In mail. Please.
Admission registered for the project. Yes, sir, in the date. Which was reopening the mother of the classification document. Ticket board. Report. Take the time to get to find out. Let's go over something. Yes, 14-15.
Lordship,
14-15.
Lordship.
14-15 কোনো করা যায় না। এইটো আমি accept কৰিব লাগিব, কেনেকে কৰিব লাগিব।
Then the matter has to be remanded to Juvenile Justice Board for passing appropriate orders.
Yes, Mr. Das, have you seen?
What?
Have you seen?
No, I haven't.
Huh?
I
The report?
No.
Go through it. Huh? You find out from the authority how it is to be forwarded to the Juvenile Justice Court. What is the observation to be made? There are authorities,
That order,
find out from a place and authority how it is to be sent.
that sentenced part will go and conviction will remain and the matter will be remanded to the trial court for passing appropriate order. I will place that authority.
Place and
Tomorrow.
authority, in the meantime, you go through it,
Okay.
right? Then we'll pass appropriate order.
Lordship.
Heard Mr. A. Ahmed Lanet amicus curiae for the accused appellant and Mr. K.K. Das Lanet additional public prosecutor for the respondent state. First of, pursuant to the order dated 22/01/2024, whereby the learned Special Judge Kokraja was asked to inquire about the factum of juvenility or otherwise of the accused appellant, comma, an inquiry report has been submitted by the learned Special Judge Kokraja along with the records of special case number 32/2019. Post up. After holding an inquiry, comma, the learned special judge in its order in his order dated 18/3/2024, has inter alia recorded a finding that has recorded a finding, comma, no, inter alia, no, has recorded a finding, comma, based inter alia on the ossification test report of the Board of Doctors, comma, that the Board of Doctors had recorded an observation, finding that the Board of Doctors had opined that age of the accused appellant was 20 years and below 21 years, comma, at the time of the examination on 11/3/2024. Full stop. Based on the said report, ossification test report of the Board of Doctors, Commander Learned Special Judge has recorded a finding that since the incident took place on 4/12/2018, comma, the age of the accused appellant at the time of the incident was in the range of 14 years to 15 years on mathematical calculation. Full stop. Mr. Das, Learned Additional Public Prosecutor, has sought petular due. Petular due. Is that petular due? Petular due. Friday? First listing of the case on Friday to enable him to make submissions on the inquiry report. To get the
अब लग गई।
It might over record. It will very good. You go through the inquiry report, inquiry proceeding. You need? Have you gone through? You need any?
Yes, I have seen. So if it is registry, maybe directed to furnish a copy. I will go through it again. Lord.
Office to furnish a copy of the inquiry report each to Mr. Ahmed Learned Amicus Curiae and Mr. Das Learned Additional Public Prosecutor by tomorrow.
अब लग
সহি করে মিটিং করে দিব, কোথায় দিব?
Item number 6.
May I please, Your Worship? Well, as per Loazima order, dated 28/6/24, service upon respondent to is complete, my lord. So.
Heard Mr. B. Borua. Complete? 302?
302, only thing, my lord.
302 or what?
Yes, yes.
That's all. Learned counsel for the accused appellant and Mr. K.K. Das, learned additional public prosecutor for the respondent number 1, State of Assam. Full stop. As per order dated 28/6/2024 of the Loazima Court, the notice upon the respondent number 2 has been duly affected. Full stop. As the paper book is ready, come office to list the case for hearing in due course.
My lord, he was a police person, my lord. Because of this, he was
Then
discharged.
he does not get any immunity
Can it be in the month of September, my lord?
according to period of detention.
Obliged.
He does not get any immunity.
He is in jail my lord, for last 2 years. My lord.
People are in jail for 5, 6 years also.
Only he is a police.
No privilege.
Seven and eight.
Obliged.
ইনতে কোনো প্রিভিলেজ না পায় disadvantage. Yes, MS Sharma.
Lordship already direction to list it for hearing, but again listed for order.
Oh, is it?
Yes.
Okay. MS B Sharma, learned amicus curiae for the appellant in so and so. I got to repeat for you. B Bhuya for the and U Chaudhary. আগৰটো আগৰটোৱে ৰিপিট কৰি দিব আগৰখিনি ৰিপিট কৰি দিব বুজিছে আগৰটো যিখিনি আছে the office is to list the cases in for hearing after a week on a date to be fixed by the in the hearing column after a week on a date to be fixed by the
Item number 9.
Service report.
As per office note dated 15/7/2024, the informant has been served.
report
Lordship received as.
order of admission was by single bench
Perhaps, my lord. Yes.
not perhaps
Yes.
definitely
Yes, I was not there.
now what is so I got rules আর notification গুলো আছে নাকি
But sentence is of 10 years, so
10 years.
probably it will be before the single.
What?
bench.
High Court rule says,
Than 10 years.
10 years or more than 10 years.
More
Two
than
chapter
10.
আছে idea আছে না পাহৰি যাও নহয়
Otherwise, it's a conviction under 22C NDPS Act.
চাই লও ভাল হ'ব কিবা নোট দিছে নেকি অফিচ নোট দিছে নেকি কিবা নাই দিয়ে rules for warning habeas corpus revocation email appeal 78 78
Notification খন আছে নেকি?
criminal business appeal
Yes. I think there's a judgment of this honorable court also. To that effect.
rule chapter 2 chapter 2
Lordship, I found 2019 notification.
more than 10 years
Yes. All matters where sentence of death penalty, imprisonment for life or sentence of more than 10 years has been awarded shall be heard by the division bench. So Lordship, it's a matter relating 10 years of it. I said,
single judge except those in which sentence of death penalty imprisonment for life or sentence of imprisonment for period of more than 10 years
I know.
more than 10 years
Yes.
I think it should go to single bench
Single.
perhaps office to examine office to examine will put it on Mr.
As does.
as does learned counsel for the appellant and Miss P. Bhuya, learned senior counsel and additional public prosecutor, assisted by Ms. R. Das, learned counsel for the respondent state. Post of the instant criminal appeal is against a judgment and order of conviction and sentence passed by the learned special judge. Additional, within bracket additional, comma Dhupri. wherein a sentence for rigorous imprisonment of 10 years has been passed against the accused appellant. Full stop. The criminal appeal has been admitted on 14/3/2024 by a single judge. Full stop. The registry to consider the matter in the light of the notification number to likhi dibo. Notification number dated 17/9/2019 and to list the appeal before the appropriate bench. এটার তো দিয়া নাই। নাই দিয়া। Single judge দিব লাগিব। Such as may refer. Judge তো দিয়া নাই। নহয় এই notification টো ক'ত কৰি দিব? হা? এনেকে লিখক। বাকী বাদ দিয়ক। এইখিনি হ'লতো আগৰখিনি হ'ল। In this connection, it is relevant to quote the contents of the notification number so and so dated 17/9/2019. Quote করে দিব। তো আপনার as the criminal appeals were sentence of imprisonment for period of more than 10 years is to be listed, is to be heard, is to be listed and heard before the division bench, comma, the registry to take necessary steps for listing of the instant appeal.
Highly obliged. Didi
10 years correctly recorded or what? I have not seen the judgment. Huh?
It is 10 years. Like.
Okay.
Item 11.
Yes.
May please, Your Lordship. As per Lozima order.
Respondent number 2 expired. Offense is under
302, 323, but
302.
323.
Huh?
And 323.
323.
3.
323. So then there is no necessity. If they want to pursue, they will
They will.
pursue. Now, so far, your objection is concerned.
Lordship, I'll take a copy from him. I don't have anything.
Heard Mr. P.
People.
Bora, learned counsel for the applicant appellant, and MS VVN, learned senior counsel and additional public prosecutor, assisted by MS R. Das, learned counsel for the opposite party number 1, State of Assam. Post of. From the order dated 28/6/2024 of the Lower Jima Court, comma, it transpires that the respondent number 2 has expired in the meantime. Full stop. As the offense, as the conviction and sentence, as a conviction is under section 302 IPC, comma, MS Bhuyan, learned traditional public prosecutor has sought for and is granted
3 weeks.
3 weeks time to file an objection to the instant application under section 389 CRPC. Release the case after 3 weeks on a date.
Hi, Your Honors.
Item number 12.
May I be? Possibly the application for continuation of delay loss.
Yes, you have appeared.
Yes, Your Lordship.
Yeah.
For hearing item number 13.
Khuniram Gaur.
Lordship, there are 3-4 issues here. One is, let's say that circumstantial evidence part. Secondly, confessional statement. And there was a plea of mental illness, unsoundness of mind. Now the FIR is at page 4. Your Lordship.
Yes.
Page 4, Your Lordship. So FIR was filed on 10/7/2017. Sir, with due respect, I would like to inform you that about 2:20 AM today, that is on 10/7/2017, while my daughter-in-law, Srimati Sampavati Gaur, 35 years, was sleeping, my son, who happens to be the accused, killed her by dealing dowel blows on her neck. It may be mentioned here that my son has been suffering from mental illness for some time. You are therefore prayed to take necessary steps after investigating into the matter and oblige. So he is the complainant is the father of the accused. And he has mentioned that his son was suffering from mental illness for some time.
Is there any medical government?
No, Lords. There was absolutely nothing has been brought on record as far as medical certificates or any other evidence other than, let's say, this statement in the FIR as well as in the deposition part.
Whether the plea was taken during trial?
Lordship?
Plea was taken during trial. This
During the trial, in the part of the deposition that has been stated. In deposition of the complainant that has come, in the cross-examination also that has come. He has specifically stated about mental illness. Now only.
The trial court has sent the claim or no, send the.
No. Trial court hasn't taken any steps on that.
Now,
Because chapter 25 provides certain procedures and Supreme Court also has also interpreted when there is a case of unstable mind, then what is to be done?
now,
What is expected?
are
from
you
the-
going to submit, make your submission in the context of section 105 of
Yes.
the Evidence Act?
Yes.
Then
three grounds, Lordship, I will argue, so make my submissions. One is circumstantial evidence, confessional statement wise, whether there was, it was properly taken. And third is, Lordship, this mental illness.
No, burden is on you.
Lordship,
So far unsoundness of mind is concerned, the burden is on you. And how to discharge that burden?
preliminary burden is on me. Now, once 105 gives, states, 105 provides that burden is on me. Now, when a material comes before the court, before the investigating agency, whether investigating agency has a more duty to find out whether he is a person of sound mind or unsound mind. That is the question. Whether a duty casted upon the investigating agency. Investigating agency is not to kill me. Investigating agency is assist the court to find out whether this person has done the committed the murder or not.
Have you seen the second part of 105?
Yes.
Then burden is upon you first.
First burden is upon me. First burden is
But-
Lordship. Now, Lordship, we'll have to examine.
The onus is on you.
Yes, honest is
Onus is on
Onus
you
is on
to
me.
discharge.
Now, Lordship, that
Otherwise-
how the honors will be discharged.
There is a presumption of law,
Presumption of law. Yes, that is
not fact.
correct. That is correct. Now, Lordship has to examine.
Let us
If-
see the evidence.
Yes, Lordship.
How?
I'm just pointing out, submitting one thing on law, that, a insane person, whether he can prove or he can brought on certain materials on record saying that he is insane. Whether an insane person can do it.
Legal.
Whether
It is,
105
it is legal insanity.
it's not medical insanity. Yes, I'm aware
Right.
of this, Lordship. I'm aware of this. I'm aware of this, Lordship. There is a fine difference between medical insanity as well as legal insanity. I'm aware of this, Lordship. Anyways, Lordship, I will submit on that. Now, Lordship, may kindly peruse the depositions, Lordship. My case is that, Lordship, whether if in a deposition a statement comes about his illness, whether there was a duty casted upon the investigating agency and the court, trial court, to find out whether actually he was insane or he was a sane person.
You were defended by private counsel or legal state counsel?
Their Lordship, private counsel.
Private counsel.
He has taken the plea.
No, that is why I am asking.
He has taken the plea. He has taken the plea.
State counsel or private counsel? Private counsel.
Private counsel.
Okay.
Private counsel, there was a counsel for him, private counsel, and this was discussed by the learned trial court also.
Okay.
Now, Lordship, the deposition parts. Page 8, Lordship. Lordship will find the deposition of PW1. He is the complainant and the father of the accused. So father of the accused himself files the FIR saying that his son has committed the murder. So his conduct has to be also seen, Lordship, because he has himself stated that his son has committed the murder. At the same time, he states that his son was suffering from mental illness. So page 8 here, Lordship, will find accused, may I read out, Lordship? Accused is my son. This is my daughter-in-law. At the time of occurrence, I was sleeping. I am residing in a separate house from my son in the same courtyard. In the next day morning, daughter of accused Bobita Gaur went to her mother's room to awake her, but her finger entered into the wound of her mother. My granddaughter raised hue and cry. I saw the dead body of my daughter-in-law, which was lying inside the house in a bed. I did not meet my son. He came to police station and surrendered. Police came and brought the dead body for post-mortem. I lost the Ejahar. Exhibit 1 is the Ejahar. Exhibit 1 is my signature. My son assaulted my daughter-in-law with a dowel, resulting her death. Material Exhibit 1 is the dowel, which I have seen today. Exhibit 2 is the seizure list, by which Material Exhibit 1 was seized. Exhibit 2.1 is my signature. Exhibit 3 is a photocopy of inquest report. And Exhibit 3.1 is my signature. Then cross-examination part, Lordship. The occurrence took place on 10/7/2017. I did not see the incident. Police asked me to lodge the Azahar. Police asked me to lodge the Azahar. One Pankaj wrote the Azahar. I have written in the Azahar that since long my son was suffering from mental illness. When police came to our police came to our house, I carefully noticed the dead body of my daughter-in-law. I went to bed at 8-9 p.m. on the night of the incident. Accused did not confess before me. I heard from other person regarding confession. It is not a fact that my son did not kill his wife. It is not a fact that on the relevant night, my son was not present. The accused has 2 daughters, 1 son who were residing with us. Lordship, that has to be noted. The accused has 2 daughters and 1 son who are residing with us. So Lordship, other than 1 daughter who has in fact went in the morning, these 2 children, other 2 children were not examined. The house of Dilo Das, Basanta Das are situated near our house. Neighboring people and myself did not hear any sound on the relevant night. So there was no effort from the side of the investigation to examine these 2 children who were there at that on that particular night in the same house. Now PW2, let's say PW2 is the mother at page 10. Accused is my son. This is Sampavati Gaur was my daughter-in-law. The occurrence took place about 6-7 months ago. At the time of occurrence, I was sleeping. In the morning, my granddaughter informed me that her mother did not arise. I went to the house of my son and saw my daughter-in-law lying on bed. Later on, I knew that my daughter-in-law had expired. In the cross-examination part, Lordship, I do not know how my daughter-in-law had died. That's all. Now, page 11, Lordship, PW3.
Yes.
He is Debojit Das. I know the accused person. The occurrence takes place before 1 year ago at night. On the day of occurrence, it was heavily raining. Deceased is the wife of the accused. While I was in my house, the daughter of the accused came and informed me that her mother was lying dead. When I went to the house of the accused, in the meantime, police came. I saw injury on the neck of the deceased. The accused surrendered before the police. Then in the cross Lordship, I do not know how the deceased had died and who killed the deceased. Then PW4 at page 12 will also. I know the accused, deceased, and informant. Occurrence took place before 1 year ago. At the time of occurrence, it was heavily raining. I was in my house. In the morning, the daughter of the accused came and informed me that her mother was lying dead. When I went to the house of the accused, police also came. I saw the dead body of the wife of the accused. The daughter of the accused told me that her mother had died and her father was absent. Then cross-examination part, Lordship, I do not know how the disease had died. Then Lordship, the deposition of the doctor who has conducted the postmortem. It is at is PW4 at page 13. So on 10/7/2017, while I was working as M&HO, Udalguri Civil Hospital, I have performed postmortem upon the dead body of Champavati Gaur, 35 years, female, in connection with Dimakushi PS number so and so. The dead body was identified by UBC Imran Hussain, Ramcharan Gaur, Baburam Gaur, Dilip Gaur. On examination, I found the following: external appearance, average build, then a deep cut injury just below the chin in left side, 10 cm, 2 cm, 2 cm, a deep cut injury on the neck left side, 12 cm, 3 cm, 3 cm, larynx cut. Then Lordship, his opinion is at page 14. In my opinion, death is due to hypovolemic shock, which is homicidal in injury. Time since death approximate is 12 to 18 hours. Exhibit 4 is my postmortem report, and Exhibit 4.1 is my signature. Then in the cross-examination part, he says about the time. Time since death approximately is 12 to 18 hours. Now page 15 is Lordship PW6. She is the daughter who came in the morning and found the dead body. She is Bobita Gaur, aged about 16 years. The informant is my grandfather. I know accused who is my father. The deceased Sampavati Gaur was my mother. The occurrence took place on 10/7/17 at 6 a.m. at material point of time when I went to my mother's room where she was sleeping with my father. My father was not in bed at that time. I tried to wake her up, but she did not respond, and immediately I noticed cut mark injury on her neck. Then I informed my grandfather. He came there and also called my mother, but she did not respond. Then he confirmed that my mother died as a result of injury on her neck. Next, we informed our neighboring people. They also came. I also came to know that my father, who was sleeping with my mother in the previous night, went to the police station. In this regard, my father lodged an FIR with the police regarding death of my mother. Police came to our house and also seized one dove from our house in my presence, and the dead body of my mother was taken to the police station. Exhibit 2 is the seizure list. Exhibit 2.1 is my signature. The cross-examination part, I slept with my grandmother in a separate room in the same house where my father and mother used to sleep in a different room. On previous night, all of us, including my father and mother, were watching a TV serial in my grandfather's room. In the meantime, I had fallen asleep in that room, so I did not know as to when my father and mother together went out in their room for sleeping. When in the next morning I went to wake up my mother, there was light outside as the sun was already rising. I did not know as to how my mother sustained injury on her neck, as a result of which she died. Then deposition of PW7, Lordship. My name is Sarath Das. I know the informant as well as the accused. The victim was also known to me, who was the wife of the accused. All of us co-villagers. The incident occurred about 1 year ago. On the day of occurrence in the morning, I was preparing to go for my work, and at that time, while I was coming out from my home, I heard from local boys that wife of the accused had been murdered. Now, this portion, Lordship, may kindly note. In the meantime, the officer in charge of Dimakushi police station also accosted me and asked me to lead me to the house of the accused by holding an umbrella, as it was raining at that time. But this has to be noted because there are some different story has been projected by the investigation team. Accordingly, I, after holding an umbrella, proceeded to the house of the accused. very specific statements, very clear statements without any ambiguity. Thereafter, I returned back to my work. Later, I came to know that accused, after killing his wife, surrendered before the police. And in the cross-examination part, Lordship, I did not witness the incident. I do not know as to how the incident had taken place, but I came to know from my neighbor that accused killed his wife and later surrendered before police. I do not know as to who had committed murder of the accused and also did not hear who committed the murder of the wife of the accused. When I went to the house of the accused along with the OC, I did not see any other person except the police personnel. I did not see the dead body of the deceased. Now, this is very important, Lordship. This PW 8. He is the investigating officer. My name is Dilip Mili. On 10/7/2017, I was posted as officer in charge of Dimakusi police station. On that day, at 3:30 AM, accused came to Dimakusi police station for surrender and orally informed me that he killed his own wife Champavati Gaur by inflicting dowel blows on her neck while she was sleeping with him. On getting information, I arrested the accused and proceeded to the place of occurrence by recording GD entry number so and so. So he proceeded to the place of occurrence at that point of time only, as per this. But as per the version of the PW 7, in the morning, the C has to accost him to the place of the occurrence. Now, we found on getting information, I arrested the accused and proceeded to the place of occurrence by recording GD entry number 185 dated 10/7/2017. We found the dead body of the deceased in the house of the accused, in the bed of the accused, in pool of blood with cut mark injury in her neck. So he went to the house at that point of time only. As it was complete dark at that moment, as such, keeping the dead body under the charge of UBC Chandan Devnath, at place of occurrence, I returned to Dimakusi police station. Now, Lordship, they went to the accused house and they did not awake anybody in the house. Father-in-law was not aware. Mother-in-law was not aware. Nobody was aware. They went to the house of the accused and victim in the night and kept a police there. They have seen the dead body there. He came out from the place of occurrence without awaking the people who were residing there. Isn't it a little bit, Lordship, difficult to understand and difficult to believe? In the meantime, on the same day at 8:30 AM, the father of the deceased, Ramcharan Gaur, lodged an FIR before Dimakusi police station. On receipt of the FIR, I registered a case by Dimakusi case number so and so and took up the investigation of the case myself, as I had already taken up the preliminary investigation of the case on the basis of GD entry recorded by me. One more thing, Lordship, I'll just point out that Chandan Devnath, who was supposed to be there, who was posted with the dead body in that place of occurrence in the house, he was not examined. Then, Lordship, on the same day again, I came to the place of occurrence and conducted inquest on the dead body of the deceased and sent the dead body for postmortem examination and collected the postmortem report. I recorded the statement of the available witnesses at the place of occurrence under section 161 CRPC, prepared the site plan of the place of occurrence. I seized the dowel by which the accused inflicted cut injuries on the neck of the deceased, which resulted her death in presence of witnesses. But there is no statement about any blood mark or nothing, blood stain on the dowel, nothing has been stated. He just presumed that like that dowel has been in the household. There are many dowels they keep in villages. Now one dowel has been picked up without any blood stain. There is no statement of blood stain. He said he presumed that blood, that was used. It was not sent for FSL also. I also sent the accused for recording his confessional statement before the magistrate. And I collected confessional statement of the accused. I submitted the extract copy of the GD entry. Exhibit 2 is the Caesar list, and Exhibit 2.3 is my signature. Exhibit 5 is the sketch map. Exhibit 5.1 is my signature. On conclusion of the investigation, having found a prima facie case, I laid the charge sheet against the accused Dhaniram Gaur under Section 302 IPC. Exhibit 6 is the extract copy of the GD entry. Exhibit 6.1 is my signature. Exhibit 7 is the charge sheet, and Exhibit 7.1 is my signature. I did not send the seized weapon for FSL examination. Before recording the confessional statement, the accused was on police custody at the police station. So, Lordship, this has to be noted. He says that the accused was before the confessional statement in police custody.
The time for reflection was given by the trial court.
Yes, that was
By
given.
the magistrate.
That has been given later on. That time has been given. But like there was some contradiction, let's say, but as for the order, it comes in different. It may be, they may have sent him to jail. That has to be seen, Lordship. But as per the learned trial court's observation and his conclusion, it was, I mean, he was sent to judicial custody, jail custody, that means before the confession. But here he says that it's police custody. So a person who has been kept, I mean, before confessional statement was recorded in police custody, whether that can be done.
Whether on the same day the statement was recorded.
No, next day, Lordship, next day. That because
During the night.
yes,
The
here
person was in judicial custody.
as per this, Lordship, police custody, but as per other material, it says jail custody.
You can put the record of the trial court.
That I'll have
Trial court
to
by the magistrate.
correct, Lordship. That I'll have to check once, Lordship. Maybe if required, Lordship, I'll have to look.
Lordship, order dated 11/11/17 is there.
It says jail hazard.
UPP Dhaniram Gaur is produced before me from judicial custody after reflection of 18 hours. It had been explained that he is not bound to make his confession. So from judicial custody, he was taken.
From jail, he was.
Yes.
So that I have said, Lordship, that has been stated there. But like as per his statement, it's police custody.
We have to read together the statement of the.
Page 89. He was sent, page 89.
The jail hazard that has been.
He was sent for reflection to judicial custody for 1 day.
Yeah, that has been stated there. But I'm just pointing out the statement and contradiction part. Then, Lordship, I met the informant and other local people when I proceeded the place of occurrence for investigation of the case. When accused came to the police station, he was in proper dress. It was not a fact that accused did not surrender before the police station and narrated about the incident causing death of his wife by inflicting dagger blows. It is not a fact that accused has not committed murder of his wife at the time of commission of offense. It is not a fact that accused was mentally unsound at the time of commission of offense. Now, Lordship, deposition of PW9, the Chief Judicial Magistrate, before whom the confessional statement will be, who in fact recorded the confessional statement. On 10/7/2017, I was working as Chief Judicial Magistrate Udalguri. On that day, one accused Dhaniram Gaur was produced before me for recording his confessional statement by investigating officer Dilip Mili in connection with Dimakusi PS, case number so and so. On being produced, I sent the accused for reflection till 11/7/2017. She doesn't say anything about whether he were, he was sent to for reflection to jail custody or police custody. Again, on 10/7/2017, about 4 p.m., investigating officer produced the accused for recording his confessional statement. On being produced, I complied with the procedure under Section 164 CRPC and Section 281 CRPC and explained to the accused that he is not bound to make confession and that if he does so, it may be used as evidence against him. Then the accused replied that he was willing to give his confessional statement voluntarily. Being satisfied that the accused is in fit state of mind and prepared to make his confessional statement voluntarily, I recorded the confessional statement of the accused as per procedure of law and kept with the case record. After recording the confessional statement, I had given a certificate that confessional statement of the accused made before me was voluntary and true, and the same was read over to and explained to the accused and admitted by him to be correct, and accordingly the accused put his signature in the confessional statement. Exhibit 10 is the confessional statement of the accused Dhoniram Gaur. Exhibit 10(7) and 10(8) are my signatures. Exhibit 10(1) to Exhibit 10(6) are the signatures of the accused person put before me. Exhibit 8 is the order dated 10/7/2017 and Exhibit 8(1) is my signature. Exhibit 9 is the order dated 11/7/2017 and Exhibit 11(1) is my signature. So those are the orders, Lordship, that 10 and 10th and 11th. The cross-examination part, Lordship, confessional statement of the accused was recorded on 11/7/2017. It is not a fact that date of recording of confessional statement was on 11/7/17 and not 14/7/2017. It is not a fact that accused had not made his confessional statement before me. Now, Lordship, that question answers under Section 313 is a page 23. Lordship.
Confession was not retracted.
Lordship,
Confession was not retracted by him.
confession was not in 313. He said that's what I wanted to point out, Lordship, because he said it is not true. He's retracted it.
Not true,
In 313.
not true, or I am innocent.
I'm innocent. I'm innocent. I'm
But he
innocent.
did not say that
He's
it is
an
not
insane.
true.
He's an insane person here, Lordship.
Insane, I have gone through entire evidence except the father.
That's what, Lordship. I mean, one evidence has come.
None has
Lordship,
said
what
about
evidence has come?
insanity.
He's insane.
But
That,
what
I
is
mean,
the-
I mean, whether that cannot be, that can be just brushed aside, Lordship. And the father has stated, who has in fact filed the FIR. He has himself stated that he has killed and he has filed the FIR. Now his statement can be just brushed aside without investigating into the matter. Whether it was duty on the investigation or not. To see whether actually he was insane or not. Whether the duty casted upon the court or not to find this out. I'm an insane person here, Lordship. How can I reply all these questions? Now here also, Lordship, there are usual question answers, but like
313 CRPC also nowhere you have taken the plea of this unsoundness of mind.
Lordship,
In 313 statement also, you have never taken any plea of this unsoundness.
that is what I wanted to point out, Lordship. The question, that relevant question was not asked to him.
What question?
That whether he was that his father has stated that he is unsound mind.
No, that is not incriminating materials against him.
No, Lordship,
Court
if
will only put the incriminating materials.
No, no,
Respect of the charges.
no, that Lordship, that is true, Lordship. That is true. I admit that. But one thing, Lordship, that has to be founded by the court. That was a very important issue in this case. That question should have been put to him. It's not that only incriminating material will be asked to him.
Yes, yes.
There
that
may
is
be
the
certain
requirement-
materials.
That is the requirement of 313.
Yeah, Lordship,
Not- not
there
the-
are certain materials which will be required in investigating, getting the matter. And this is very relevant whether he is insane or not. That question should have been put to him. That question was not put to him under 313. All the questions were asked, but that question was not put to
No, 7 except,
Lordship.
7 except PW1.
Yes, Lordship.
What is the trend of cross-examination or defense? Who is represented by defense counsel,
That Lordship has
private
said-
counsel? Let us see then.
That Lordship is
From PW1,
that
to-
Lordship I have already pointed out, Lordship. That is that is there. That I can't help, Lordship. That is there. But the plea can be taken in this stage also.
no plea, legal plea can be taken.
Lordship.
But question is, what are the foundational situation you have made during the trial? That is also important. 313, there was nothing. No, that
that's-
he could have answered. He had all the occasion to answer. At least to say that I was.
That is what I am submitting here, Lordship. A person
There was-
who is not of his mind, he's out of his mind, whether he can himself state lot many things.
Out
And
of his mind.
whether it was expected from the court and desired from
Out
the
of
court.
his
that-
mind is one thing that if you go to page 94,
Yes, Lordship.
I don't think 93 and 94 that he is out of his mind.
No, Lordship, Lordship, yes,
The
Lordship.
things
And
have
I
to
will,
be observed pragmatically. That just because saying that out of his mind will not do.
no, I know.
That even after reflection, if he
Lordship.
says like this, suppose we accept this. It is presumed to be made
Lordship,
before a judicial magistrate at least.
Lordship.
Then cannot be said to be out of the mind.
No, Lordship, two, three things, Lordship.
And
Like,
this cross-examination is much later on. But this is immediately after the incident. And you did not dispute about your appearance before the police station.
so
There
that-
is
that-
general
that-
resident entry has been exhibited.
GD entry has been executed, but like that contradiction part, Lordship, that as I was pointing out, that has to be looked into, Lordship, because that investigating officer has stated that he came and surrendered.
PW6
Yes,
daughter.
now he stated,
From the daughter, it appears that you used to sleep with your wife
Yes.
in a room
yes.
in the same house. There is nothing by which it was controverted. Though she said that after watching TV, I fell asleep. But
she is not aware
He
whether
used
father.
to, but it is a fact that my father and my mother used to sleep in a different room in the same house. And you extracted this from PW6. She did not say in chief. You extracted it
Correct,
in the cross-examination.
correct, Lordship. No, Lordship, now, whether. the-
Now tell me
Lordship,
whether on the basis of this material, this plea of insanity can be taken.
yeah, I think that's what my submission.
Let
Lordship,
us, no submission, let us, is it backed by any authority?
No, no, I will place a case, Lordship, wherein this section 105 has been properly discussed, the duty and like the burden of proof, and whether it is preponderance of probabilities or it is reasonable doubt. As far as my case is concerned,
No, it is
Because my-
preponderance of probability.
my case is only I need to say that I'm insane.
Oh, no.
After
No, no,
I'm
no, no,
insane,
no.
no, that I'll.
Everybody will say I am insane. No, Mr.
No,
Kolita,
no,
just I have to say I am
no,
insane.
I'll have to
Oh,
say.
this is
insane.
not.
No, I'll have to say insane, then I'll have to produce certain materials. That is true, Lordship. That is true that I'll have to produce certain materials, oral evidence, documentary evidence. If it is available, I'll have to prove it. I'll have to place it. That is there. That is not, I'm disputing that. But after that, what happens, Lordship? Whether the duty casted upon the investigating.
Oh, duty
agency
will
or not.
come, but the first,
So, Lordship, that evidence has come from the father. Whether that can be discarded just like that. Another thing, Lordship, like I think in my view, Lordship, that is important because Lordship, I'll just come. Now, Lordship, may kindly come to page, Lordship was referring to page 89.
Eighty-nine?
Page 89, Lordship. Lordship has got it. This is Lordship that the procedure of or recording of confessional statement. Lordship. So I'll just read out, Lordship. Date 11/7/2017. The accused, namely Dhaniram Gaur, is brought before me on 10/7/2017 by IO Dilip Mili at courtroom at about 4 p.m. to have his confessional statement recorded. I have ascertained. So, Lordship, this 10/7/2017 is not correct. It was on 11/7/2017. So 10/7, Lordship, it was the first day. 10/17 in the morning hours, he was brought to the courtroom. Then he was,
This accused, namely Dhaniram Gaur, instead of was brought. It should
then
be
no,
was.
Lord, at the time part, Lordship, at about 4 p.m. It was not 4 p.m. 4 p.m. on 11th.
Have you seen that? As here.
I could not see it, Lordship. I should have, Lordship. I didn't get much time. Lordship, I'll just, Lordship, before I go ahead, Lordship, I may require some time to, Lordship, study this matter a little bit more in depth. But I would like to finish off Lordship, at least certain.
Time out. 18 or 23. Not a single application was ever filed during the committal stage, investigation stage, inquiry stage, or trial stage regarding mental
That is not required, Lordship,
illness.
as per the Supreme Court law, Lordship. Without that also that plea can be taken, Lordship. That is true, Lordship, admitted fact. It was not filed.
No, thought that it is prudent to look whether any
Yes, yes,
plea
yes.
such is taken or
Correct,
not.
correct. Yeah, Lordship is very correct, but like they have not filed anything else.
What is the manner required for retracting a confession?
But I mean, as far as my knowledge goes, Lordship, I mean, there is no specific way to do it. But if it is denied,
Where is the
And-
denial?
when it says that I am innocent, but that specific question was not put. That's what I was stating here also. 313, there was no question put to him about this. So there was no occasion came to, in fact, directly say.
Come to question number 8. And 9.
Yes, sir. May I read out, Lordship? PW9 Gita Lira was stated in her evidence that on that on 10/7/2017, while she was working as Chief Judicial Magistrate Udalguri, you were produced before her for recording a confessional statement by the investigating officer Dilip Mili in connection with so and so. On being produced, she sent you for reflection till 11/7/2017. Again on 11/7/2017. At about 4 p.m., investigating officer produced you before for recording your confessional statement. On being produced, she complied with the procedure under section 164 CRPC and section 281 CRPC and explained to you that you are not bound to make confession and that if you do so, it may be used as evidence against you. Then you replied that you are willing to give your confessional statement voluntarily. What you have to say in this regard? I am innocent. Then 9 Lordship Gita Lirava further stated in her evidence that being satisfied that you in a fifth state of mind and prepared to make your confessional statement voluntarily, she recorded the confessional statement of yours as per procedure of law and kept with the case record.
Next
After-
part. Next part.
After recording the confessional statement, she had given a certificate that confessional statement of the accused made before her was voluntary and true, and the same was read over and explained to you and admitted by you to be correct. And accordingly, you put your signature in the confessional statement. Exhibit so and so is statement so and so. And what is your reply in this? I am innocent. Now, Lordship.
Read over and explain.
Yes, yes. Lordship, my question is, my anxiety is whether an innocent person can understand this. He can stand this trial. That is the basic. That is the basic. A person who is not in his mind, whether he understands these things, whether he can stand trial, whether court found out whether he can stand trial or not. Trial court.
While recording his statement, confessional statement, the magistrate has observed that he was in fit state of mind.
Yes, that has been stated.
So do we disbelieve the magistrate? Is there any material to disbelieve her?
No, now Lordship, that's what Lordship, I wanted to bring your Lordship to page 89. For a second, Lordship. There's a huge contradiction, huge, wide contradiction as far as surrender is concerned. Whether that aspect has to be taken into account or not by this court. Page 89, Lordship, in the bottom paragraph, Lordship, I'll read out, Lordship. He was sent for reflection to judicial custody for 1 day. Thereafter, Lordship, I have asked the accused in detail relating to his detention after arrest. And she stated that he was arrested he was arrested, he was surrendered before Dimakusi police station at about morning 7:30 AM. He surrendered at 7:30 AM, not at 3:30 AM as stated by the investigating officer, and detained in the police station for about 7 hours, 9:30 AM to 3:30 PM before being brought to the court. Whether any explanation given by the prosecution why this discrepancies has happened? There is no explanation. Nothing has been discussed on this. Then Lordship, another thing, Lordship, I would like to point out.
Cross-examination, whether you put any question to the magistrate. PW9.
As for this, nothing, Lordship. That is
Then-
not, that is not there. That is not there. I'll have to admit that is not there. Now, as far as Lordship, his conduct, Lordship, first of all, Lordship, in general norm, a person who commits a murder, he doesn't surrender usually, in usual course. In usually he doesn't surrender, he tries to elope, he tries to go away. That is one thing. Secondly, Lordship, I'll just point out couple of inconsistencies about his statements, about his mental condition, Lordship. Lordship may kindly come to the charge hearing. That is there at page page 28, Lordship. Let us read this thing together with other depositions, Lordship. Page 28, your Lordship will find Lordship will find on the bottom, at the bottom of the page, there was a question. You have been found guilty in this case. Do you have anything to say? He stated, I beg to be forgiven. I have 2 daughters. I'm on this list, Lordship. I have 2 daughters.
Son was not mentioned.
Now, Lordship, as far as the statement of deposition of father of the accused, page 9. He specifically states that accused has 2 daughters and 1 son who are residing with us. Then again, Lordship, at page 90, page 90, there was a question, Lordship, whether you are married, have got children. I have 1 child. A father stating, page 90, your Lordship. Whether you are married and have got children, we have 1 children. Is it intentional, Lordship, that a father will give different versions about his children?
From these answers, can it be said that he is mentally not sound?
No, that's what, Lordship, we need to examine, Lordship, because I mean, a father, if he's sound, his sound mind, whether he will state in one place that I have only 1 child, and another place he will say I have 2 child, and father will and like his father, grandfather will say there are 3 children. Is it normal, Lordship? He's very inconsistent, and there was nowhere during the trial process he was actually examined or actually examined whether he was a insane person or not?
Mental illness. And
No, it's a difficult proposition, I understand, Lordship, but like I just wanted to
Insane
assist your
person.
Lordship. I just wanted to assist your Lordship whether this can be,
what is the requirement for the accused to say that to activate the provisions of section 328, more particularly section 329.
so Lordship,
Also section 105 of the Evidence Act, section 84 of the IPC. What are the minimum requirements?
correct, Lordship. So that is,
Let us
Lordship,
see the proposition.
yes, Lordship.
What is the
Lordship,
minimum requirement?
yes, Lordship, that is what.
Have you set up those? Have you set up those requirements?
Correct,
Or the
Lordship,
court? No, otherwise, if you're on the basis of the materials available on record or brought on record, father, the person who has said it is your father. There could be various reasons. Now, what is the minimum requirement for the court to examine the case of the petition accused from the point of insanity?
So Lordship, I tried to borrow.
Whether it comes within the general election, what is the proposition?
Correct, Lordship,
Subtle proposition.
right, Lordship, I tried to borrow.
Otherwise, if it is accepted, it will be very difficult to conclude a trial. If just because something is appearing mental illness, it's very difficult to go because you have to set up the plea. You have to set up the plea so that the court can exercise the power under section 329.
That is correct, Lordship. What I
Now,
submit
what
is that,
is the minimum requirement?
so, Lordship, my submission will be, yes, Lordship, there may be,
Onus is on you. And what is the authority you want to cite?
so I borrowed some of my submission and I'll have to borrow some of my submission from this case, Lordship.
Okay.
This is Lordship 2023 5 SCC 673. Prakash Nai versus.
The learned trial court, so far as retracted confession is concerned, have elaborately dealt
Uh,
on the basis of the settled position of law,
correct.
right? Do you have anything to say about that?
No, that's what Lordship, I mean, as far as father's statement is concerned, that aspect was not properly, I mean, why that has been discarded, that was not properly discussed. Why it was discarded? Father's statement, why it was discarded? Why it was not taken into account, not given the importance?
Okay, which paragraph?
Lordship, from paragraph 7 to 17, it's a very detailed discussion, Lordship. I'll have to read out all these paragraphs, Lordship, because the line is very thin, Lordship, as I stated. The initially, Lordship, they discuss about from paragraph 3 to 6, they discuss about unsound mind, what is unsound mind, what is medical insanity, and what is legal insanity, and all these things. But as far as Lordship 105 is concerned, Lordship, that the query, Lordship, come from the Lordship, that has been discussed in this paragraph, from paragraph 7 here, Lordship. If your Lordship allows, I'll read out. Section 105 of the Evidence Act 1872, the burden of proving that case of accused comes within exceptions. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in Penal Code 1860 or within any special exception or proviso contained in any other part of the same code or in any law defining the offense is upon him. and the court shall presume the absence of circumstances, of such circumstances. Para 8, the burden of proof does lie on the accused to prove to the satisfaction of the court that one is insane while doing the act prohibited by law. Such a burden gets discharged based on a prima facie case and reasonable material produced on his behalf. The extent of probability is one of preponderance. The extent of probability is one of preponderance. This is for the reason that a person of unsound mind is not expected to prove his insanity beyond a reasonable doubt. Secondly, it is the collective responsibility of the person, the court, the prosecution to decipher the proof for insanity by not treating it as adversarial. This is what I am stressing on also. This is what I am stressing on, that there is a duty casted upon the investigating agency as well as the court. Though a person is presumed to be sane, once there are adequate materials available before the court, the presumption gets discharged. Section 105 of the Evidence Act 1872, which places burden of proving, has its exceptions. Though as a general principle, the onus is upon the person accused to bring his case under the exception dealing with the case under Section 84 IPC, one has to apply the concept of preponderance of probabilities. The aforesaid provision has to be read along with Section 8 of the Evidence Act 1872. The better way to reconcile the aforesaid provision would be to have a look into the behavior and conduct before, during, and after the occurrence. So I was just pointing out the behavioral aspect and like his inconsistencies in his statements, and which is very, which is known to him. Section 10, paragraph 10, as per Section 84 IPC, has its laudable objective behind it. The prosecution and the court have their distinct roles to play. The agency has to take up the investigation from the materials produced on behalf of the person claiming unsoundness. In this case, nothing has been done. It has to satisfy itself that the case would not come within the purview of Section 84 IPC. The court on its parts has to satisfy itself as to whether the act was done by a person with unsound mind within the rigor of Section 84 IPC. So it has specifically given a duty to the court also. Now 12, Lordship, we wish to place reliance on the classical decision of this court in Dayabhai Chaganbhai Thakkar versus State of Gujarat, wherein the court held that the doctrine of burden of proof in the context of plea of insanity may be stated in the following propositions. The prosecution must prove beyond reasonable doubt that the accused has committed the offense with requisite mens rea. And the burden of proving that the burden of proving that always rests on the prosecution from the very beginning to the end of the trial. It's not only during that investigation stage, till the end of the trial. There is a rebuttable presumption that the accused was not insane when he committed the crime in the sense laid down by Section 84 of the Penal Code 1860. The accused may rebut it by placing before the court all relevant evidence, oral, documentary, or circumstantial. The burden of proof upon him is not higher than that rests upon the party or upon a party to civil procedure. Even if the accused was not able to establish conclusively that he was insane at the time he committed the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of ingredients of the offense, including the mens rea of the accused. And in that case, the court would be entitled to acquit the accused on the ground that general burden of proof resting on the prosecution was not discharged. Then, Lordship, paragraph 13, the court in Bapu has held the onus of proving unsoundness of mind is on the accused. But where during the investigation previous history of insanity is revealed, it is duty of an honest investigator to subject the accused to a medical examination and place that evidence before the court. And if this is not done, it creates a serious infirmity in the prosecution case, and the benefit of doubt has to be given to the accused. The onus, however, has to be discharged by producing evidence as to the conduct of the accused shortly prior to the offense and his conduct at a time or immediately afterwards, also by evidence of his mental condition and other relevant factors. 12. The mere abnormality of mind or partial delusion, irresistible impulse or compulsive behavior of a psychopath affords no protection under section 84, as the law contained in that section is still squarely based on the outdated M. McNaughton's rules of 19th century England. The prohibitions of section 84 are in substance the same as those laid down in the answers to the judges to the questions put to them by the House of Lords in M. and McNaughton's case. Behavior antecedent, attendant, and subsequent to the event may be relevant in finding the mental conditions of the accused at the time of the event, but not that remote in time. It is difficult to prove the precise state of offender's mind at the time of commission of the offense, but some indication thereof is often furnished by conduct of the offender while committing it or immediately after the commission of the offense. A lucid interval of an insane person is not merely a cessation of a violent symptoms of disorder, but a restoration of faculties of mind sufficiently to enable the person soundly to judge the act. But the expression does not necessarily mean complete or perfect restoration of mental faculties to their original condition. So if there is such a restoration, a person concerned can do the act and with such reason, memory and judgment as to make it legal act, but merely a cessation of the violent symptoms of the disorder is not sufficient. This court in a recent decision in Devilal Loka Rathore versus State of Maharashtra has held that section 84 IPC carves out an exception and that an act will not be an offense if done by a person who at the time of doing the same by reason of unsound mind is incapable of knowing the nature of the act or what he is doing is either wrong or to contrary to law. But this onus on the accused under section 105 of the Evidence Act is not as stringent as on the prosecution to be established beyond all reasonable doubts. The accused has only to establish his defense on a preponderance of probability as observed in Surendra Mishra versus State of Jharkhand, after which the onus shall shift on the prosecution to establish the incapability of the exception. But it is not every and any plea of unsoundness of mind that will suffice. The standard of the test applied shall be legal insanity and not medical insanity as observed in the State of Rajasthan versus Seraram as follows. Lordship, what is that 105 basically ratio is that if I place some material and which give me the benefit of probability, preponderance, then my burden shifts to them. Then they have to prove it. The burden shifts to them, then they'll have to prove it that I am not an insane person. So my case, Lordship, before your Lordship, is that once that aspect has brought to the record of this court, that should have been examined in a proper manner to come to a conclusion that this person is sane and he can face the trial. That hasn't been done in this case. The crucial then after that, Lordship, the State of Rajasthan versus Seraram, once a person is found to be suffering from mental disorder or mental deficiency, which takes within its ambit hallucinations, dementia, loss of memory, self-control, control at all relevant times by way of appropriate documentary and oral evidence, a person concerned would be entitled to seek resort to the general exceptions from criminal liability. The crucial point of time for considering the defense plea of unsoundness of mind has to be with regard to the mental state of the accused at the time the offense was committed, collated from evidence of conduct which preceded, attended, and followed the crime as observed in Ratanlal versus State of MP. It is now well settled that the crucial point of time at which the unsoundness of mind should be established is the time when the crime is actually committed, and the burden of proving this lies on the accused. In Daябhai Chaganbhai Thakkar versus State of Gujarat, it was laid down that there is a rebuttal presumption that the accused was not insane when he committed the crime in the sense laid down by Section 84 of the Indian Penal Code. The accused may rebut it by placing before the court all relevant evidence, oral, documentary, and circumstantial, but the burden of proof upon him is not higher than which rests upon the party to a civil proceedings. If from the materials placed on record, a reasonable doubt is created in the mind of the court with regard to the mental condition of the accused at the time of occurrence, he shall be entitled to the benefit of reasonable doubt and consequent acquittal as observed in BJ Singh versus State of UP. Now, Lordship, the Supreme Court discusses on the Chapter 25 of Code of Criminal Procedure. 15. Chapter 25 of the Code of Criminal Procedure 1973 here of the CRPC, though a procedural in nature, also becomes substantive when it deals with an accused person of unsound mind. A well-laid procedure is contemplated under Section 328 to 339 CRPC. There is not even a need for an application under Section 329 CRPC in finding out as to whether an accused would be sound enough to stand the trial. Rather, it is mandatory duty of the court. So, Lordship, application may not be required, Lordship. Under Section 330, court can even go to the extent of discharging such a person, if his inability to stand trial continues with a rigid chance of improvement. As per Section 334 CRPC, the judgment of the court shall include a specific finding that the act was committed due to unsoundness of mind, though it was actually done. The reason is simple, as there cannot be an acquittal on the ground of unsoundness of mind unless the act is actually done. The whole idea under provisions discussed is to facilitate a person of unsound mind to stand trial, not only because of his reasoning capacity, but also to treat him as the one who is having a disability. The role of the court is to find the remedial measures to do complete justice. So, in my humble submission, Lordship, court has not put any effort to find out. So that's why he has been denied justice, Lordship. He has been denied justice because court has not taken any effort to find out this aspect of the matter. They have simply brushed aside that specific deposition of the father. Having noted the scope and ambit of chapter so-and-so, including persons incorporated by way of amendment so-and-so, one has to take into account the fact that court has a larger role to play while considering a case under Section 84 IPC. If a friendly approach is required to be followed during the trial, when adequate powers have been conferred upon the court, even to discharge an accused on the ground of an unsound mind, the same reasoning will have to be applied with much force when it comes to Section 84 of IPC. So this is the ratio which has been laid down and proposition which has been laid down. So therefore, once Lordship, it was pointed out, it was brought to the notice of the court that the person may be suffering from insanity. And there is a a reasonable apprehension and there is a probability, then court has to take it up. Investigating agency has to take it up. They have to discharge their burden.
Voluntary and true. Voluntary part is one first stage, second is true. Then entire edifice on mental illness will fall down. Kindly come to PW1. Let us read it once again.
Yes, Lordship.
I have written in the Azahar
Yes,
that since long my son was suffering from mental illness.
correct.
And
Lordship.
I have written in the
Yes, Lordship.
FIR.
Yes.
It is not like that my son had suffered from mental illness. I have written in the FIR.
But what about Lordship? The
And since long,
yes.
but the version in the FIR is Kisudin Dhori.
So that-
Kisudin Dhori Manohik Bhabe Bharohaimyohীনতাত ভুগি আছে. If the story of 164 the accused has given before the magistrate appears to be true, then this Kisudin Dhori is related to that. It is not a case of unsoundness of mind. It is disturbing mental disturbance which led him to commit the offense.
No,
We have to see all the pictures
correct, correct. Lordship. Lordship,
because
Lordship,
you have not
Lordship.
shown any mental treatment about undergoing anything, semblance of any semblance.
That is not there, Lordship. I cannot go beyond that.
Any iota. There is nothing.
No, Lordship, one more thing, Lordship. What
And he said, I have written in the Azahar.
no, Lordship, before that, Lordship, this is in the cross part, Lordship, because he hasn't written the Azahar himself. In the before this, Lordship, what he has stated,
Your mother did not say anything,
mother didn't say anything, Lordship.
right? Your
Yes,
daughter did not say anything. Your neighbors did not say anything.
But there was lapse, Lordship. There was
And
lot of.
IO was categorical.
So, Lordship, here, Lordship,
IO was categorical. It is not a fact that accused was mentally unsound at the time of commission of offense.
I was Lordship not properly.
Anyway, we are not.
So,
giving
Lordship,
any-
here, Lordship, I have written in the Azahar means, Lordship, because he hasn't written the Azahar himself. It was written by somebody else. One Pankaj has written the Azahar.
No, he did not deny the Azahar. He did not deny the Azahar.
No, he did not deny the Azahar. So that's what, like, he's saying that, like, he has written it. that is-
He lost the Azahar.
Yes, I lost the Azahar. he
Exhibit
said-
1 is the Azahar. Exhibit 1 is my
And Lordship,
signature.
it becomes more important that, like, if it is said that Kisudin Dhori,
Any other?
Kisudin Dhori, that means,
Any
Lordship,
other
at the
point?
time of committing the offense, he was suffering from this.
Any other point?
Yes, Lordship. Other points, Lordship, that surrender, Lordship, that surrender. The surrender part, Lordship, has to be looked into, Lordship.
Let us see the GD entry.
Lordship, I will take your Lordship to first to this thing, his deposition. IO's deposition.
Yes.
So he categorically village stages also, Lordship.
We'll consider.
They have, yeah, Lordship, yes,
We
Lordship.
have heard enough on the point
Lordship,
of
Lordship,
insanity.
though it was not raised very strongly there with some documents, but like I'm raising it now. Now, like page 19, Lordship. On 10/7/2017, I was posted as police officer in charge of Dimakushi police station. On that day, at 3:30 AM, accused came to the Dimakushi police station for surrender and orally informed me that he killed his wife Champavati Gaur by inflicting dowel blows on her neck while she was sleeping with him. On getting information, I arrested the accused and proceeded to the place of occurrence. That has to be noted, Lordship. Proceeded to the place of occurrence. That means immediately he has gone to the place of occurrence. We found the dead body of the deceased in the house of the accused, in the bed of the accused, in pool of blood with cut mark injury in her neck. As it was complete dark at that moment, as such, keeping the dead body under the charge of UBC Chandan Devnath at the place of occurrence, I returned to the Dimakushi police station.
Only two discrepancy, PW 6 and PW 8. He said after recording the GD entry, he proceeded. He did not mention the time. PW 6, the daughter, she said that at 6 AM, she came to know, and at that point of time, there was light.
Right.
And this man, Ayo said, there was complete darkness. We don't know whether he went prior to 6 AM or after 6 AM.
No, Lordship, what he has written, what he has
Tell me the
stated.
time.
No, what he has written, Lordship, as it was complete dark moment, as such, keeping the dead body under UBC Chandan Devnath at the place of occurrence, I returned to Dimakushi. What does it mean, Lordship? He has gone to the place of occurrence at that point of time, and it was total dark at that point of time. He kept one police officer then in the house, and he came back without waking up the residents of the place. Can it be believed, Lordship? Why the police officer has police officer, he went there, a murder has occurred there, and he did not wake up the father, the mother, everyone. Nobody was waken up. And he kept one person there, one police officer there, and he came back. Lordship, can it be believed? And Lordship, what PWD 5 says? PWD 5 says, Lordship, may kindly come to PWD 5 statement. PWD 5 is the neighbor at page 17, Lordship.
PW 5 is the doctor.
PW 5 7, Lords. I'm sorry. PW 7, page 17. PW 7. I'll just read out, Lordship. On the day of occurrence, from the third line, on the day of occurrence in the morning, I was preparing to go for my work. And at that time, while I was coming out from my home, I heard from local boys that the wife of the accused has been murdered. In the meantime, officer in charge of the Dimakushi police station also accosted me and asked me to lead me to the house of the accused by holding an umbrella, as it was raining at that time. Accordingly, after holding an umbrella, proceeded to the house of the accused. Thereafter, I returned back to my work. Later, I came to know that accused. So what does it mean, Lordship? If he has gone to the place of occurrence in the night itself,
Who?
this OC, then what was the need for him to again accost him to the house place of occurrence in the morning?
Yes, there. Yes, there.
And lordship, GD entry doesn't say that he has gone to the place of occurrence.
Who?
That, officer in charge. Page 79 is the GD entry.
The contents of the GD entry is
Page 79, lordship.
consistent with the FIR regarding the time.
Lordship. In the
GD entry
confessional
is stated
statement,
at
he states
30.
that, in the confessional statement, he states that he surrendered at 7:30 in the morning. And GD entry says he surrendered at 3:30. And that his deposition says after the GD entry, he proceeded to the place of occurrence. And he kept one person there, and he came back.
Uh, in the confessional statement, that is recorded as per the version of the accused.
No, lordship, yes, lordship, version of the accused. So he states that he has surrendered in the 7:30 in the morning.
But the GD entry and the FIR speaks otherwise.
That is what, lordship, why this inconsistencies? And why GD entry doesn't say that like he has proceeded to the place immediately?
What is the law on inconsistency about half an hour, 45 minutes?
Lordship,
What is the law
law on what, lordship?
on inconsistency of time period?
Time period. That, lordship, I'll have to look into. In a criminal case, lordship, at least some explanation has to be there from the side of the prosecution.
6, doctor. 16.
But this is very surprising, lordship. He goes to the place of occurrence at night and he doesn't wake up anybody.
Confirmed another trial.
This is totally not believable.
Which part is not believable?
What I'm saying is that like a police officer,
But the accurate is that on the basis of information furnished by you, he had recorded the GD entry and visited the place of occurrence and found the dead body there.
correct, and he doesn't wake up the residents there. Can it be believed? In my house, a murder has occurred. Police has come to my house at night at 3:30, and nobody was waken up. I mean,
Whether it will cause any dent to the prosecution versus.
yes,
that
lordship,
is
they
a
have to.
murder detail,
That's what his deposition cannot be believed. His story is not true.
which one?
His story is not true because that
There is
his
only inconsistency in respect to the time.
what I'm saying is that-
Time factor.
yes, lordship, what I'm stating
is
is
what-
that what I'm stating is that if he has visited the house of occurrence, first of all,
Just
the left
because this granddaughter of the informant, it is daughter of the informant, had said that it is 6 AM, she came to know that occurrence took place.
yes, lordship,
That all these discrepancies appear to have emerged.
correct, lordship.
But this man, Ayo, proceeded to the place of occurrence after 4 AM.
That I do not know from.
But because you have not consulted the place.
Okay.
Then at 5:40,
Hmm.
he left the place. So what is the presumption that these inmates of the house were not there?
No, that is what Lordship, whether inmates, why inmates were not waken up,
Yeah.
why no statement
Okay.
came.
Anything more? If anything more, we'll
That Lordship,
resume at 2 then.
small, a couple of things. Lordship,
Resume
just point
two.
out. I'll just point out, Lordship, two aspects from this, his deposition only, page 19, Lordship. That I was reading, Lordship. Then I'll conclude, Lordship. Lordship, as I, on a middle portion, as I was reading,
Yes.
as it was complete dark at that moment, and as such keeping the dead body under charge of UBC Chandan Devnath at the place of occurrence, I returned to so and so. Chandan Devnath Lordship is a vital witness as far as surrender is also concerned, as far as commission of the offense is also concerned. He was not examined, Lordship. He was not examined. Then two children were not examined, who were there on that particular night in the house. Then lots of this dhow was seized towards the bottom, Lordship. I seized the dhow by which accused inflicted cut injuries on the neck of the deceased, which resulted her death in presence of witnesses. Now, I don't know how this presumption or assumption, what may be the word that can be coined, how it can be concluded that that dhow was used, because there was no blood stain. There was nothing has been stated like this. It was not sent to the FSL also. So others, Lordship, I have already covered. Only these some vital witnesses were left out, and duty casted on the investigation and the court as far as section 105 that I will submit that was not complied with, and his plea of mental illness was not properly considered, and a person who was not mentally well was actually put on the trial. That's my humble submission. Okay.
Postmortem doctor was not cross-examined except one line.
Lordship. Yes, Lord, that was not It was,
So he suggested that date was 12 to 18 hours
yes,
prior to postmortem.
correct. Lord.
That makes it in between 10 p.m. to 2 a.m. About 2:30
Lordship.
a.m. 10:30 p.m. to 2:30 a.m.
2:30.
So that version tallies with the approximate date, time of date of the
The Lordship, that is true.
and the act of alleged act of surrender. Subsequent to that, it was at 3:30 perhaps. Alleged act of surrender was at 3:30 as per the GD entry
Yes, Lordship.
79. 3:30. Yes, madam.
Actually, in the case in hand, the prosecution proved the conviction and sentence under section 302 beyond reasonable doubt, my lord. Here, although my learned friend has taken a plea at this stage, the plea of unsoundness of mind, my lord. So, lordship, at the face of it, lordship, under section 328 of CRPC, if the magistrate want to exercise the power, your lordship, then that the magistrate has the reason to believe, my lord, that the person is suffering from unsoundness of mind. Since the convict didn't take any plea to that effect, your lordship, regarding his insanity, whether at this stage he can take the plea, your lordship. And another factor is that the occurrence had taken place during the four corners of the house, my lord, during the wee hours, my lord. And thereafter, your lordship, after committing the crime, the accused person surrendered with a weapon of offense. And lordship, in another connection is that he confessed his
Not
guilt.
with the
My lord.
not with the
Oh,
weapon.
yes, I'm sorry, your lordship. He surrendered in the police station, my lord. And thereafter, lordship, there was a confessional statement. And the lordship, adequate measures have been taken under the High Court rules, my lord. All the procedures have been followed, my lord, while recording the confession, my lord. And he did not retract that confession, my lord. So in the event of the matter, your lordship, if your lordship takes into account the confessional statement, he did not, in confessional statement also, he did not take that, it has not taken that plea that he was suffering from any mental ailment, my lord. In that event of the matter, your lordship will assume that he is in a fit state of mind at the time of commission of the crime, my lord. In sound mind, he has committed the offense, and the reason why he has committed the crime, my lord, he has cited the reason in the confessional statement that he suspected his wife, my lord, as his wife did not reply to the questions query made by him. He cold-bloodedly murdered her. So in the event of the matter, your lordship, my lord, learned trial court has rightly convicted the accused person, my lord, under section 302 of the Indian Penal Code. And regarding the another lordship, the injury which has been committed by the victim, lordship tallies the statement recorded in the 164 vis-a-vis the postmortem report, my lord. It was the vital part of the body on the neck. Lordship, may I take your lordship to the confessional statement at page 89, my lord, once. Relevant portion is at, my lord, page 93. Down below, my lord. I love my wife Champavati Gaur. There was no quarrel between us. I never assaulted her. For the last few days, my wife did not prepare food for me properly. My mother consoled her to take care of me. I suspected that my wife had developed illicit relation with someone. On the night of the incident, I asked my wife several times as to whom she used to meet. As she did not reply me, I got angry and took a dao lying nearby and hacked her. I did not deal the dao blow on my wife with the intention to kill her, but as a sustained injury on her neck, She fell down instantly. She sustained injury on her neck. As I committed a mistake, I decided to commit suicide by consuming poison. I tried to commit suicide by consuming insecticide but failed. On the following morning, I surrendered at the PS. I have only this much to say. Lordship, let us go to the postmortem report, my lord, which is at page 72, my lord. Lordship, wounds, position and character at page 73. A deep cut injury just below the chin in left side, 10 centimeter, 2 centimeter into 2 centimeter. A deep cut injury on the left side, 12 centimeters. So it's on the portion of neck, my lord, just below the chin and on the portion of neck, as a result of which the victim died instantaneously, my lord. So which tallies the lordship confessional statement. And regarding the other point taken by my learned friend that the material witnesses have not been examined. Lordship, if the witnesses which have come up before this or before the trial court could prove the case beyond reasonable doubt, I don't think there's a lapses on the part of me. There may be lapse on the part of the investigation, but that will not falsify the prosecution case, since this, there is a clear confessional statement on the part of the accused person. And your lordship, there are two parts your lordship have come across the vernacular portion, that manokik uttejana and manokik vikriti is two different aspects of the matter. Unsoundness of mind and mental anxiety. He might be suffering from mental anxiety, my lord, but may not be suffering from mental illness. So as to take the benefit under section 84 of the Indian Penal Code. Lordship, I want to take one citation. Oh. 2008, 7 SCR 767. Maybe that's. Seven SCC, 700. They are looking at you like the SCR. 2018, 7 SCR, 767. Lordship, para 9 on PW 14 in his examination in chief stated that the appellant was caught immediately after he made the assault on 26/9/2006 and brought to the police station. The FIR was registered the same day, but the appellant was taken in custody only on 28/9/2006 because he was not keeping well and had been admitted in a hospital. The information of his arrest was not given to his sister or mother, but only to his friend Nagarao Waghe, who has not been examined. In view of the previous history of insanity of the appellant as revealed, it was a duty of an honest investigator to subject the accused to a medical examination immediately and place the evidence before the court. And if this is not done, it creates a serious infirmity in the prosecution case, and the benefit of doubt has to be given to the accused, as observed in Bapu versus State of Rajasthan, 2007, 8 SCC 66. The admitted facts in the present case strongly persuades us to believe that the prosecution has deliberately withheld relevant evidence with regard to the nature of the appellant's mental illness, his mental condition at the time of assault, requiring hospitalization immediately after the assault, and hindering his arrest, the diagnosis and treatment. The evidence of the treating doctor, all of which necessarily cast a doubt on the credibility of the prosecution evidence, raising more than reasonable doubts about the mental condition of the appellant. Unfortunately, both the trial court and the high court have completely failed to consider and discuss this very important lacuna in the prosecution case, decisively crucial for determination or adjournment of the guilt of the appellant. The law undoubtedly presumes that every person committing an offense is sane and liable for his acts, though in specified circumstances it may be rebuttable. The doctrine of burden of proof in the context of the plea of insanity was stated as follows in Devyabhai Chaganbhai Thakkar versus State of Gujarat, 1964, 7 STR 361. The prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. There is a rebuttable presumption that the accused was not insane when he committed the crime. In the sense laid down by the Section 84 of the Indian Penal Code, the accused may rebut it by placing before the court all the relevant evidence, oral, documentary, or circumstantial, but the burden of proof upon him is no higher than that raised upon a party to civil proceeding. Even if the accused was not able to establish conclusively that he was insane at the time of committing the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of the ingredients of the offense, including mens rea of the accused, and in that case, the court would be entitled to acquit the accused on the ground that the general burden of proof resting on the prosecution was not discharged. Section 84 of the IPC carves out an exception that an act will not be an offense if done by a person who at the time of doing the same, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or what he is doing is either wrong or contrary to law. But this onus on the accused under Section 105 of the Evidence Act is not as stringent as on the prosecution to be established beyond all reasonable doubt. The accused has only to establish his defense on a preponderance of probability as observed in Surendra Mishra versus State of Jharkhand, 2011, 11 SSC 495, after which the onus shall shift on the prosecution to establish the inapplicability of the exception. But it is not every and any plea of unsoundness of mind that will suffice. The standard of this to be applied shall be of legal insanity and not medical insanity, as observed in State of Rajasthan versus Shera Ram, 2012, 1 SSC 602. Once a person is found to be suffering from mental disorder or mental deficiency, which takes within its ambit hallucinations, dementia, loss of memory, and self-control at all relevant times, by appropriate documented oral evidence, the person concerned will be entitled to resort to the general exception from criminal liability. The crucial point of time for considering a defense plea of unsoundness of mind has to be regarded the mental state of the accused at the time of the offense was committed. Your Lordship will kindly note that part. Collated from evidence of conduct which preceded, attended, and followed the crime as observed in Ratan Lal versus State of Madhya Pradesh, 1973 SCC 533, as follows. It is now vessel that crucial point of time at which unsoundness of mind would be established is the time when the crime is actually committed, and the burden of proving this lies on the accused. In D.G. Thakkar versus State of Gujarat, it was laid down that there is a rebuttable presumption that the accused was not insane when he committed the crime in the sense laid down by Section 84 of the Indian Penal Code. The accused may rebut it by placing before the court all the relevant evidence, oral, documentary, or circumstantial, but the burden of proof upon him is no higher than that which rests upon a party to civil proceeding. If from materials placed on record, a reasonable doubt is created in the mind of the court with regard to mental condition of the accused at the time of occurrence, he shall be entitled to the benefit of the reasonable doubt and consequent acquittal, as observed in Vijay Singh versus State of UP, 1993 SCC 190. We shall now consider sufficiency of other medical and defense evidence to examine if reasonable doubt is created with regard to the mental state of the appellant at the time of commission of the assault on a preponderance of probability, coupled with a complete lack of consideration of the evidence of PW 14. Merely because an injured witness who may legitimately be classified as an interested witness for obvious reasons may have stated that the appellant was not of unsoundness of mind, cannot absolve the primary duty of the prosecution to establish his case beyond a reasonable doubt, explaining why the plea for unsoundness of mind taken by the accused was untenable. Lordship, other things may not be so material. So in our case, nothing has been done, my lord, nothing. No material, no documentary evidence to that effect, my lord, to take the plea.
One line is there in the confessional statement that he tried to commit suicide, but he could not. Yes, he could not.
So, Lordship, in order to commit suicide, a person may not be suffering from unsoundness of mind.
But that is one of the character.
Not all the time, because of anxiety also, your lordship, since he's suffering from mental anxiety. So he lordship at the time of commission of the crime, lordship he lost his sense and tried to commit suicide. When he lordship realized that he has committed a crime. Then para 16 of the judgment, lordship, the medicines which has taken by that accused, well, it has been elaborated. In the case in hand, they have taken the plea. The prosecution tried to, lordship, conceal that fact. So it's when the accused person take the plea, the rebuttable presumption on the part of prosecution that he was not suffering from unsoundness of mind. So in the case in hand, he has not taken that plea, my lord. So no chance of rebuttal.
So that has to be collaborated. So I haven't placed all these cases, lordship is aware of this. So that has to be the last resort. I mean, confessional statement, that has to be corroborated by certain.
Corroborated by other.
So that I'm not
That
placing.
cannot be
the
the
lordship
basis
is-
of.
Yeah, lordship is already aware of this. And like as far as circumstantial evidence and confessional statement, that lordship is aware, I have not placed it.
Basically, two aspects. One is whether it is perfectly voluntary. And the second is whether it is
True.
Truthful.
Correct.
so voluntariness can be seen from the proceedings before the court magistrate. And second part, whether truthfulness can be examined in the context of the other evidence on record.
That's what. Confessional statement.
First in point of time, GD&G has been exhibited. Act
And-
of surrender, that is a conduct under section 8 of the Evidence Act.
And he is
And
present, he has
the
not denied.
conduct of the accused preceding, attending, and subsequent are factors to be taken into consideration.
Correctly, in this case, lordship, those factors were not, in fact, brought on record properly.
Have you read the trial court judgment?
Yes, I have read it. I have read the whole judgment. Also.
Dealt with all the issues.
So he has elaborately written, that has to be appreciated. But the only thing is that like mental part, lordship, he hasn't discussed about his father's evidence properly. I mean, like why he has totally discredited it. He has stated, I mean, otherwise it has been like, as far as confessional statement is concerned, he has elaborately discussed, very elaborately.
Lordship, may I submit, if any reasonable doubt appears in the mind of this noble court, Lordship, after perusal of materials and record.
Since you are reserving the judgment,
Lordship, I can still call for a report from the jail authority. I leave it to your
Regarding-
lordship discretion.
Report regarding?
What?
His mental this
Yeah.
thing, but at that point.
It's up to your lordship. If your lordship still some doubt arises, then his conduct is whether he's normally behaving with other.
That will be appreciated from the prosecution.
Only two lines. One is one line in FIR.
My lord.
The second line is in the cross-examination of PW1.
PW1, father.
That's all. Nothing else.
Yeah, they were about the conduct inconsistencies, about his son, daughters. His commission of suicide. I mean, these are
Normal person
these
also
are mental
sometimes, my lord.
instabilities, your lordship. A normal person doesn't commit suicide after committing murder.
Normal person does so, my lord, because the realization comes, my lord. He has committed a heinous crime.
Remorse.
My lord,
Have
remorse.
you read the judgment of this open last cross case?
Yes. My senior was in fact there in that case, so like he made read it couple of times.
10/7. 2017 was the incident. Judgment was 31st July 2019. 2 years.
Yes.
Heard.
Some
Mr.
benefit of doubts, maybe lordship.
A. Colita.
He had
Fine.
children.
Amicus curiae for the accused appellant and Miss Vivian Lanet, Senior Counsel and Additional Public Prosecutor, assisted by Ms. R. Das, Lanet Counsel for the respondent state. Arguments are heard. Judgment is reserved.
Obliged, your lordship. Proposal has come, lordship may consider that.
Up to
She
your
is very,
lordship.
fair- no, she is very fair on this.
No, if
I'll have to
any
appreciate.
reasonable lordship doubt arises in the mind of this honorable court, then only his lordship.
Obliged, your lordship, for a patient hearing. Lordship.
Item number 15.
Mr. Bhattacharya, we have, I don't know for what reason, there is a single bench and time is fixed at 3.
No, it's
Or
an
natural-
appeal against acquittal.
Huh?
It's an appeal against acquittal.
Okay. Or natural matter, some virtual hearing. I
Madam.
don't know. I think to take this. We need to what interview taken. Someday else. You are for the appellant?
I have been appointed amicus.
Okay. Where is the counsel for the appellant?
My lord, if I remember correctly,
Ah,
while Justice Koteshwar Singh was there, they had submitted that the file was
Ah.
taken away from them.
okay.
Then I was appointed amicus.
Okay. Mr. D.K. Bhattacharya, learned counsel. Learned amicus. Curie. For the appellant and Mr. Who are the accused?
There's supposed to be 8 accused persons.
Hmm?
Name is shown.
Name is shown.
They are the main person. If appeal is allowed, they are to suffer. And Mr. K.K. Das, learned additional public prosecutor for the respondent state. Full stop. Learned counsel for the respondent number 129. State has not been made a
State
party.
is the last respondent,
Huh?
if I'm not wrong. State is the last respondent.
No. CPS, you have a party.
Oh, no, no, minor. State has not been made party.
State has not been made a party. Anyway, 1 to 9 are found absent today on card. In view, as the appeal is against the acquittal, comma, in view of non-representation on behalf of the respondent number 1 to 9 today on call, comma, let the appeal for inch of justice be listed after a week on a date to be fixed by law. Yes.
May it please your lordship. I am appearing on behalf of
Yes,
Mr.
sir.
A.R. Gogoi, my lord.
Hmm.
In this matter, lordship was pleased to issue notice on 13th of June, my lord. It's relating to a prayer for promotional avenue for the drivers, my lord. We have served extra copy on all the respondents also. So they are just required to submit their affidavits, my lord.
Yes. Mr. Patin?
Yes. This extra copy was served, but it was served very lately. On receipt of the extra copy, I have written to the respondent number 1 for giving of Parawas reply. Then till now,
You appear for
I have
respondent number
not
1.
got any instruction. Yes.
And who appears for
Lordship, I'm
respondent number
appearing,
2?
I'm appearing for respondent number 2 and 3, Lordship.
2 and 3.
3, Lordship.
You have received the
I have-
copies?
I have been served only one extra copy. If one more can be served to me, Lordship.
I'll endeavor to do that, lordship.
Okay. Yes, Mr. Patin, how much time you would require? How much time?
I have already written and forwarded the extra copy to the Registrar General for furnish of the Parawas reply. So I expect that
Lordship,
1 month.
Lordship, at least 4 weeks time may be given, Lordship.
And Mr. Patin? 4
Ah.
weeks.
4 weeks, Lordship.
4 weeks.
Okay. You serve an
Oh,
extra copy?
Yes, lordship.
Mr.
U. Pathak, I am appearing for
U.
A.R.
Pathak,
Gogoi.
Learned Counsel. Heard Mr. U. Pathak, Learned Counsel, appearing for Mr. A.R. Gogoi, Learned Counsel for the petitioners, and Mr. M. Patin, Learned Senior Counsel and Standing Counsel, Guwahati High Court, Itanagar Bench, assisted by Mr. Assisted by?
Purton.
Mukbang Purton.
Mukbang
Mhm.
Purton. MUKBNG.
Bit louder.
Mukbang
Louder.
Purton. Mukbang Purton. Mukbang.
Why Patin?
MUK
Why Patin?
M. Partin.
M. Patin. Learned Counsel for the respondent number 1. And Mr.
Mr. S. Tapin, Subhu Tapin, Lordship. I'm senior government advocate here, Lordship.
Okay, Mr. S. Tapin.
Lordship.
Tapin.
TAPI.
Senior Government Advocate.
Lordship.
Arunachal Pradesh for the respondent number 2 and 3.
Correct, Lordship.
Mr. Tapin has submitted that only one extra copy of the writ petition along with annexer, was served upon him. So he has submitted that another copy of the writ petition along with annexer be furnished to him. Post of Mr. Soin Pathak, Learned Counsel for the petitioner. Appearing for the petitioner has undertaken to serve one extra copy of the writ petition along with the annexers to Mr. Tapin, Learned Senior Government Advocate, within 3 working days from today.
In this.
Full stop. Both Mr. Patin, Learned Senior Counsel and Standing Counsel GHC, Itanagar Bench, and Mr. Tapin, Learned Senior Government Advocate, Arunachal Pradesh for the respondent number 2 and 3, have sought for 4 weeks' time to file their respective counter affidavits. So the prayers are allowed. Release the case after
Closed.
4 weeks.
12/8.
12/8.
Lordship.
Obliged.
12/8.